I want to look at this from the employer's point of view. So I have an employee who is a whistleblower. Is there a difference in the process if that case gets picked up by the Department of Justice and they prosecute the case versus a key TAM attorney who's prosecuting it on behalf of the government without the Department of Justice? Does it look the same to me in terms of the process, in terms of the outcome, or is there a difference?
From the employer's perspective, there is a perceived difference. In reality, there is no difference.
I assume the perception is the Department of Justice has these endless resources because they're the federal government. So
they have an endless resource. They can bring an FBI guy with a gun. They have a lot of things that you as an individual private attorney don't have. But you as an individual private attorney have all the legal power of that United States attorney in issuing subpoenas and discovery and investigating the case. So from a legal procedural perspective, it's the same thing.
My risk is the same. My cost of defense is the same. The protection on the whistleblower is the same. The rules of engagement don't change.
They're all the same. And in fact, most cases are not intervened by the DOJ. Most cases are in fact taken by private attorneys after the DOJ has declined intervention. And that could be because they don't have the resources at that time to handle it. That being said, the largest recoveries ever within the False Claims Act have occurred on cases that were not intervened.
So effectively, the Department of Justice is outsourcing part of their prosecution to private attorneys.
Absolutely.
Because they are working still on behalf of the government, using the whistleblower to start the process, but they're representing the federal government.
Absolutely. The whole thing is effectively outsourced to attorneys that know how to deal in federal court with the False Claims Act.
And obviously those attorneys have a level of incentive that an employed attorney from the Department of Justice doesn't have, who's on salary. So there's a great deal of motivation for an attorney to prosecute that case if they think they can win the judgment.
Oh yes, absolutely. They're difficult cases. They take a long time. They're very expensive. And the motivations include, as I said, 15 to 30% is the whistleblower portion of the fines and penalties. That's 3 times damages plus penalty between $5,500 and $11,000 per claim. That's just the penalty part. Those numbers get very big very fast. The second part is retaliation provision, which is double back pay, double damages, plus mandatory attorney fees and cost. And then wrap the whole thing with mandatory attorney fees and costs. It's not unusual for a False Claims Act case to end up in a settlement to where the attorney fees and costs are actually higher than the full settlement amount. These are very expensive situations for businesses to find themselves in. They are bet your business kind of situations.